said don't fight the system. They said stay quiet.
They were wrong. Lock in. We are exposing what so many have failed to. We are gonna show you what bar attorneys have hidden from all of us. Hundreds of thousands of children and twice that of parents have been lied to and walked down the road of termination. It's the death penalty. We're all of the protesters, the ones who fight for the rights of prisoners, dogs, illegal immigrants. Why aren't you coming to the aid of our children and families right here in America every day is child per minute is kidnapped?
And no one cares. We fight alone until today. CPS punishers mount up. Here comes the CPS Punisher.
Anonymous tip, another lie from one of them. No warrant, no roof, just a badge and a grin. Stealing kids like trophies, thinking they'll win. Mama crying on the porch, daddy in the cage. System wrote the script, but the CPS Punisher just flipped the page. The educator they banned, I see every violation, every forged line, every ex-part hearing, every stolen time. One tap of the app and the truth ignites. Welcome to the CPS Punisher, now we can fight.
CPS and the courts have lied to us all.
The courts will not disgrace the family.
CPS Punisher, hit more chains and expose again.
CPS Punisher,
the educator they never wanted you to find.
Punisher,
One tap and their empire cracks. We rise, we take our kids back. The app is called the CPS Punisher.
I'm the cape in the shadows, the skull in the night, the binder full of secrets, the weapons you all need. Ab initio, watch me void that lie. Fourth Amendment armor, watch the tyrants cry. Falsified drug test gone in a flash. Every old warrior due process king. Every parent hero when the hotline rings. I call it justice. Download the truth, now the system busts us. From the courtroom to the streets, hear the battle cry. The CPS Punishers arrive. Kiss your bar asses goodbye. They tried to silence us, now we're the loudest voice in the room.
CPS Punisher,
Here to avoid the chains and expose the game.
CPS Punisher,
The educator they never wanted you to find.
Punisher,
The children never leave again. Families rise, we never look back. We now use the CPS Punisher. This ain't revenge, this is reunification. This ain't rage, this is resurrection. Open the app, step into the fight. You ready?
CPS Punisher,
The app you need when they took your kid.
CPS Punisher,
The truth they hid, now the truth gets lit.
Punisher,
Download the power, take back the throne.
Punisher,
You're never alone. CPS Punisher, the educator they never wanted you to find. Void complete, family restored. The bar is finished, the Constitution will prevail. Judges do what's right. Treason is your penalty.
CPS Punisher,
Here comes the CPS Punisher.
When the courts aren't blue saying fair, you have pulled out your last hair.
The law isn't on your side. These corrupt judges take you for a ride. The courts don't want to even oppose. That's how we know it's corrupt. My disability has a name. We're all equal and the same. All alone in the courtroom floor, waiting for your hero to bust right through the door. It's hammering Hank every time. He's the one toeing the line. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. In the court they do have rules. They don't treat you like your jewels. You deserve all the commodities just because we have difference in our bodies. The law is made for us all. They don't protect us that have files on. He's the answer man you need to be calling. He puts it to an even field. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. When you're a bit different, to phone you free. The playing field is equal, what do you bet? That judge has to toe that line. The oughta make sure every time. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. Hammering Hank. Hammering Hank. Hammering Hank.
Well, hello everyone. Welcome to Equal and the Same, our Saturday Night Lovely polka. Love that song Darren made for me. It's more a little bit of a cheer up situation, but it's 11:29. I hope everybody had a great Thanksgiving. Wow, we heard some great news tonight. I guess we have a new app for the system for people to try out, and it's an app that's gonna kind of like look at your case details and see if it can pick up on anything and be able to give you some advice or it catch maybe errors and things like that in law. I heard Darren say it was better than Westlaw. Well, Westlaw to me is a pain in the ass because we're not allowed as a reasonable accommodation to do our research from our houses. We have to go down to their facilities, their hours, their times, and end up, doing what little research we can do instead of at our convenience, our speed, our timing, our inconvenience. For the last couple of weeks, I just been hearing a couple things too about the transportation issue. I happened to go into the Department of Social Services website the other day, and within that website, on their first line, it was underneath the ADA, non-medical transportation services. So again, I continue to people to say, well, if DCF is saying I need to get my own ride, well, then why ain't they coordinating with your state's Department of Social Services? Similar in the same to a dial-a-ride if your state doesn't even offer what I'm talking about, that you can use that as a pretense because it is a medical condition, because they're saying that you need medical treatment in this reunification plan or whatever they put forth to make you to go to supervised visitation or go see a shrink or whatever. But so I mean, it's kind of like interesting. So what was kind of blowing my mind too today was I was thinking about what I wanted to do with everyone. And this is a story that I continue to hear from everyone, that your child was taken away, you don't even know what you did, but somehow they're accusing you of some medical negligence or whatever. There's a case in the state of Connecticut called in Joseph W. It ended up going to our second court of appeals under Watley versus Keller. He tried going after the judge and all the other players because what they were doing and what they weren't recognizing was that there's an administrative duty. And if you can't prove compliance, then who am I dealing with? It'd be sort of like, again, I'm asking for a brain surgeon, you're giving me a foot doctor. How is this even remotely connected to be the same therapeutic benefit that others would receive, like in a domestic violence situation? You wouldn't go see a foot doctor then. You wouldn't go see for a child abuse situation, a physical abuse, because obviously all of ours are perceived harms. There could be some cases of we heard of children having fragile bone syndrome. It's the best I can describe it, where the child's bones were breaking easy. We've heard of an X-rays showing that there would have been a cracked rib at some possible time. And again, these are all things that we all go through life and we all get. I mean, I got chips and bruises and things on my body that just wouldn't end. Some of it was from midget football. So again, I'm not sure, what this will lead to. But anyways, what I want to start, hopefully, is an MP3 player. And what we're going to do is listen to this whole trial within 5 years. And remember, not only do you as a parent have, quote unquote, the right as a normal person or a cured person to meet your child and reintroduce you to them as whatever they're trying to portray that you need to be. And again, not only that, the child would have disabilities because, again, in my opinion, if the child was abused emotionally, mentally, physically, not only the trauma of ripping the child out of their home and putting them into an institutional setting, that in itself can cause post-traumatic stress. And again, the ADA would be clearly protecting that child in that right. So when they talk about, and it irks me, and I might stop it a couple of times because I get really mad. It was the ACLU of Connecticut, which, in my opinion, was a very weak argument, and they actually talked this gentleman out of asking the courts for custody of the children. They were seeking remedy, and where I continue to say to you, remedy is an open door. It's to whatever is going to make the person whole again. And then on top of it, it would be part of the disability that the need for intensity. In other words, if you were a disabled person and you had a harder time cognitively picking up things, like let's just say how to bounce a quarter on a bed, or you can't cook, or somebody might even say, you only got one arm. How are you gonna, change baby's diaper? I mean, whatever it's going to be, whatever they're putting as a technical barrier and using your disability as a technical barrier, because they're not supposed to be doing that. Your disability is not supposed to be looked at as a hindrance. They're supposed to give you the effective means and tools to get around the disability. So again, I'm not sure what we can do here, but let's at least fire this up. Hey John, hey hi Erica. Glad you guys could join in tonight. And again, if you guys got any questions, just pop them up into the chat box, because this is going to blow your mind how the Second Court of Appeals 5 years ago is getting it wrong too. And they're getting it wrong purposely, because again, they're not looking at the facts that to become compliant, you have to have administrative duties complied with. You have to give a right for objection at the point of identification of discrimination. You have to be given a procedural safeguard and told that there's these benefits and these modifications if somebody perceives you as being disabled. If you identify, that's another factor. And then there's just the plain old common sense, disabilities, where if you see there isn't an automatic door and there's a person coming up in a wheelchair chair, who's going to go over there and hold the door for them? I mean, that's just morally correct things to be doing. So again, this is my whole thing tonight, is just to listen to this, and let's see if we can get into it. So let me see if I can get her playing.
First case on our calendar is Watley.
Can somebody say you can hear this?
And we have attorney Dan Barrett on behalf of the appellant. Good morning, counsel.
Good morning, Your Honor, and good morning to the court.
Can anyone hear this in the chat box?
Ilana Bildner, I represent the appellants, Joseph Watley and Karen Hasman, in this matter, which is back to you.
You're good, bud. You're good. All right, thank you.
12B6 dismissal decision from the District of Connecticut.
So can you speak up? I'm having a hard time hearing you.
Yes, Your Honor. Can you hear me now?
Yes, much better. Thank you.
Great. Thank you, Your Honor. So, as I say, this case is back to the court for the second time in 7 years on a pre-discovery 12B6 decision. And it poses the question of whether parents who have disabilities or perceived as disabilities may enforce the ADA or the Rehab Act in the national court system when they've been prevented from doing so in the state courts. And since the District of Connecticut's dismissal decision rested in part on jurisdiction, perhaps I might start there. This case is not a Rooker-Feldman case for two very important reasons. The first is that the injuries that the plaintiffs complain of were not generated by the state court judgment that the defendants point to. In fact, the injuries that the plaintiffs complain of arose beginning in 2005 and 2006 in the out-of-court services provided by the defendants during the TPR and the termination of parental rights and neglect litigation.
So when you talk about their injuries, they're not seeking their children back. Isn't that correct?
That's absolutely correct, Your Honor. There's no request and no illusion that any action in the national courts could restore their children to them. They do not seek to displace that judgment of the Superior Court.
Well, Mr. Barrett, what are the damages that they seek? Do those damages not include the pain and emotional suffering from losing their children?
Your Honor, the damages, because the injury they complain of is the failure to be given the access and opportunity to the rehabilitation or reunification services, the damages would be limited to what a jury determined it was worth for them to be cut off from those services.
Well, but I mean, that doesn't quite answer my question. These folks, as far as I can tell, and you can correct me if I'm wrong, were not seeking out services. It's not like they went to a welfare agency and said, please give us some help with parenting. They were being required to engage in those services as a condition of not losing their parental rights. Yes?
That's right, Your Honor.
So what, is one of the items of the suffering and pain that stems from not getting the services the loss of the children that results, or not?
Yes.
No, Your Honor. I think in the context of this case, that is fairly off the table, because the injury is simply the access and the opportunity to use the services. But then
that brings me back to my other question. Are we talking about basically nominal damages, or because again, or the insult, the dignitary harm of not having the right sort of reunification services for its own sake and in and of itself? That's the key damage item here.
Yes, that's correct, Your Honor. And this court has passed upon those many times in the past. For example, Bartlett versus New York Board of Law Examiners, the dignity harm for not having an accommodation on the bar exam, Loeffler versus Staten Island University Hospital, the the same harm for failing to have been provided with an ASL interpreter.
Yes,
So,
and could you give me, I'm sorry, go ahead.
My conceptual problem is I have a great deal of difficulty even conceiving what you believe the accommodation in this context would be. You have two and then later one dysfunctional parents. You have a state whose obligation is to protect these newborns from ostensibly incompetent parents. And the whole process was trying to deal with their disabilities, counseling service, medication, working with them when they would miss appointments and weren't taking their medication, and so forth and so on. What is it that was supposed to have been going on that would, in your view, would look like an accommodation?
Sure. Well, Your Honor, we never got that far in the District of Connecticut, but to give you two very quick examples, Ms. Hasman, for example, was diagnosed at multiple times with severe narcolepsy. And she was nonetheless, and if you look at page 172 in the Joint Appendix, she was dropped from counseling for sleeping through the sessions, which is a direct, it's a symptom of the very disability the state contends her to have. So then you foresee a federal court superintending and micromanaging this process, which is, not the kind of thing we usually do. That they, she should have been able to miss 3 sessions rather than 2, and she should have had psychotherapy 5 days a month rather than 4, that sort of thing? Well, Your Honor, to be fair, the national court system assesses ADA accommodation disputes all the time as to a range of—
Not like this, it doesn't.
Your Honor, these services, the rehabilitation and reunification services, we are looking at the out-of-court action. So it is simply a program and service provided by, in this case, the state of Connecticut. And it can be assessed just as with any other ADA dispute, wherein Mr.
Well, could I address that, Mr. Barrett? I think I understand your point that there's no collateral estoppel with respect to the legal issue of did this DCF violate the plaintiff's ADA rights as such. But in terms, and maybe that means this court has to do more thinking about this. But in terms of the facts, you're saying they did not deal adequately, for example, with the mother's narcolepsy. Isn't that fact something that they were able to raise in the state proceedings? Because doesn't that fact go to the question of whether the DCF
Sorry, I forgot I had my mic off. But at this point right now, this is when I start getting infuriated. It's fact. Compliancy. If you're non-compliancy, you cannot turn around and offer anything, because how would you know without a self-evaluation of all your tools in the tool arsenal and how to apply it it's insane. I'm hoping I can hear John, but I'm going to go back to it right now, buddy.
In connection with the reunification efforts, is that fact something that you would be able to relitigate in the ADA case?
I hope you can hear it,
May I
Erica.
continue to answer your question?
Of course.
Thank you. So, Your Honor, what is silent in the record is the relevant facts to an ADA analysis. So, for example, what accommodation Ms. Hasman and Mr. Wiley would have proposed in order to make the playing field level for them to access these services.
Would they have to propose one? Or would the state be required to do that sua sponte?
Well, Your Honor, this is the very catch-22 that the court is finding itself examining, which is that the parents did not propose that as an ADA accommodation because the Superior Court would not rule on that issue.
No. We're not talking about what happens in court. We're talking about what happens in the field, right? You're saying it's not about what happened in court. It's about what happened at the level of the provision of services in the first place. Were they required to propose an accommodation at that point? And if they were, did they?
Well, Your Honor, you'll notice that is not in the record in the decision relied upon by the defendants. But to answer your question, no, nothing prevents parents in the out-of-court services from demanding an accommodation, or indeed for the state from offering one.
And would anything have prevented the plaintiffs here from arguing in the state court that it was necessary for them to have these accommodations and they were denied, and that undermined the requirement that the state make reasonable efforts to reunify, taking into account any disabilities?
Yes, Your Honor, it would have been prevented for the reason that there are two distinct analyses. The ADA focuses on the access and opportunity to the services. The state law examination that the Superior Court.
Well, I'm trying to make this. Excuse me. I'm trying to make this very concrete. If I'm fighting to keep my children, and one of the requirements that the state has to prove in order to take away my children is that they made adequate efforts to reunify the family, taking account of my disabilities in assessing what services needed to be provided, why can't I argue that in light of my disabilities, this particular thing was done badly and it should have been done differently and I should have gotten an accommodation? What is there that prevents that from being raised? I don't have to call it an ADA claim. That maybe there's no way to make a counterclaim that says, you're trying to take my children. I'm filing a counterclaim that says you didn't comply with the ADA. You can't do that. I understand
28
that.
CFR 35.107. The designated responsible employee is the only one that can determine discrimination in a state program, service, or activity.
And that's exactly what
by Congress.
You can't call it something else.
Or it's DOJ, guys.
Well, I suppose you could, Your Honor, but the venue will construe it as raising a defense based on the ADA and tell you, as the courts did 3 times, that it's forbidden under Connecticut.
Why didn't you simply file, before judgment in the state court, why didn't you simply file a standalone ADA claim in federal court? That would have mooted all the Rooker-Feldman issues, wouldn't it?
Well, it would have, Your Honor. The parents filed this action pro se. And so I don't have an answer as to why they didn't do that, but strictly in terms of Rooker-Feldman, the state court judgment did not cause their injuries, right? No state court judgment required the services to be provided in a way that violated federal law. So Rooker-Feldman here is I think, not the main event. Their injuries were not caused by the state court judgment. And of course, nothing that the District of Connecticut will eventually do will cause that decision to be reversed or to compel the defendants to take an action contrary to the state court judgment.
But if it's not Rooker-Feldman, we still have to deal with the collateral estoppel possibilities. Was there ever an effort by the plaintiffs to say that the services were not provided in a way that took adequate account of our disabilities in order to constitute the kind of reunification efforts that the state requires.
Yes, Your Honor, and that was at the second.
And the state court said, no, that's wrong.
The state court said that it's unclear what remedy is sought if, in this case, the mother was not attempting to assert the violations as a defense to the adjudication of neglect. That is to say, the state court was saying those concerns are not part of reasonable efforts. They are something separate and apart, and in accordance with state law, they're to be enforced in a separate lawsuit.
I don't follow that at all. That's quite different than what you just quoted. Your paraphrase is quite different. The court says, unless it's to be interpreted as an ADA claim, it's not successful because it does what was done satisfied the state's obligation. And what I'm trying to get at is maybe you get to go with an ADA claim independent of Rooker-Feldman, but I'm still not clear as to what facts you could possibly allege that were not available to you in the termination proceedings as an argument that the state's obligations were not complied with.
Well, Your Honor, it's less of a question of which facts were available to us and the question of whether the forum was available. You know, the law of issue preclusion requires that the issue be fully and fairly litigated. The parents here, by operation of state law, could not raise, for example, proposed accommodations and arguments about whether or not those accommodations were sufficient. Those were.
That is far from clear to me. The hypotheticals I would mention, they were perfectly free to take issue with the medical services, the counseling services, and so forth and so on. You know, I didn't get the right medication. Give me some different medication. I didn't get enough or the right kind of counseling, and on and on and on. All of those issues could have been raised in state court.
Your Honor, I think the gap between the two is that the ADA is a different analysis. That is to say, what passes muster for reasonable efforts does not necessarily satisfy the ADA. And so all along the course of the litigation, it's entirely possible, and at points they did raise a variety of problems related to the services, and the state court ultimately concluded that's no bar to reasonable efforts.
Yeah, but see, the path you take us down with that analysis seems to me leads to the conclusion that the ADA litigation is going to completely supplant these state court adjudications, which are much better equipped to deal with, you know, people like your clients.
Well, no, Your Honor. The state court adjudication simply determined at the end whether or not my clients would have the ability to continue as parents for their children. There's
but you skip back between the end and the process. The process was an ongoing process that went on for years to try to get your clients the services they required in view.
Well, with respect, Your Honor, I think the process was the services that were given to them. And the question was not, the ultimate question is not whether, given those services, they would have the legal right to parent their children. The ADA question here is, given the services that were offered, were those services tailored to their disability? Nothing about that.
What were they if they weren't tailored to the disability? You think they gave them the wrong kind of medication?
Well, for example, Your Honor,
psychologists who weren't trained? What are you talking about?
No, Your Honor, this would be the normal sort of access and opportunity measures that you would find in any run-of-the-mine ADA case. So, for example,
you lost me there. I don't believe that.
Well, Your Honor, the question with any ADA Title II claim is whether or not the service that was offered was tailored to the person's disability. They were given a meaningful opportunity to use the service. And so in any ADA case, you are on some level going to be examined whether or not there was a modification that was appropriate. The defendant has the opportunity to say that it could not have provided it, et cetera, et cetera. That's, I think, routine for ADA litigation. The question here is, of the services that were offered, it's not whether under state law they were substantively the right services. It's whether, for example, when Ms. Hasman, who has a series of diagnoses that may lead you to believe that she has difficulty comprehending information, was failed out of parenting education because she had difficulty comprehending the concepts. That's your ADA question.
To wind up, now you reserve 2 minutes for rebuttal. Let's hear from Connecticut. Counsel, good morning.
Good morning, Your Honors. May it please the court, my name is Jane Rosenberg. I'm representing the Connecticut Department of Children and Families, Commissioner Durantes, and former Commissioner Katz. The district court correctly dismissed this case, as I think Your Honors have recognized, because the plaintiffs want to litigate all of the issues that were previously litigated in state court.
But the argument is that they weren't litigated because they couldn't raise their ADA claims in the termination proceedings.
The ADA, what they call the ADA claims and the termination proceeding both involve the identical issue, which is whether the DCF accommodated the plaintiff's disabilities in providing their services. And the standards under the ADA and the state termination statute are the same. In both cases, the parent's mental disability must be taken into account. And it's a fact-specific, case-by-case analysis that looks at the effectiveness of the particular accommodation modification that's being offered, and also, in the case of the ADA, considers the cost. In this case, the state court conducted extensive proceedings that culminated in a 193-page opinion in which the court concluded by clear and convincing evidence that DCF had made reasonable efforts to reunify the parents with their children, and in fact had done everything possible to assess the parents' disabilities and address them. The court went on to note that it was in fact extraordinary, some of the efforts that DCF took. And I must say, with a 193-page opinion, there really was not an issue that was untouched here. That if this court were to order an ADA case to go forward, it would effectively be relitigating every issue in this case.
No.
Now, the plaintiffs say that they couldn't raise their ADA claim, but as I said, under collateral estoppel, it's the same issue here. It's the issue is whether the parents' mental health, mental disabilities were accommodated, and that's precisely what the court was getting at. And in fact, even in those instances when the plaintiffs did specifically say we're raising this as an ADA claim, there was no prohibition, there was nothing jurisdictional, there was no bar in the state courts to raising an ADA claim. It's correct that the courts did say that the ADA is not a defense to a termination proceeding, but that does not mean that you cannot raise the accommodations and whether they were appropriate to accommodate the parents' mental health. And this was demonstrated well in the second termination trial, in which, in that case, the plaintiffs had counsel who did raise the ADA claims and raised it in the context of the ADA and said we are not getting proper accommodations. And the court looked at the issue and said the attorneys presented evidence and made arguments, and the court concluded that there was insufficient evidence of any additional services that should have been provided, and ultimately concluded that the ADA was not violated and the plaintiffs have not been discriminated against. Now, that decision was vacated, not on the merits, but because the underlying neglect decision was reversed on appeal, which meant that the termination decision had to be vacated. But it's significant because it shows that there is not some inherent bar in the state court process that prevents someone from making these arguments that...
Okay, Ms. Rosenberg, I think I understand that argument. I just want to be absolutely clear. You're not suggesting that the plaintiffs here are precluded by a factual finding that was made in the second trial, are you?
Correct. Because the second trial was vacated, that has no preclusive effect. But I think the significance of it is it demonstrates that there's nothing inherent in the state court system that prevents plaintiff parents from making these arguments. In the other trials,
but are we talking about making arguments or litigating claims?
well, we're specifically.
I mean, I could say, of course, you could make ADA-like arguments there, I suppose, but how is that an adequate opportunity, really, to vindicate your ADA rights?
Because the issue is the same. We're talking about issue preclusion and not claim preclusion here. And the identical issue is at the core of the ADA and the termination proceeding analysis. In both cases, you are specifically looking at the modifications and accommodations that were provided by DCF and whether those accommodations accommodated accommodated the mental disabilities of the parents.
Well, if that's so, Ms. Rosenberg, does that suggest that the district court needs to do a more granular analysis and that this may not be something that can be dealt with at the pleading stage? Wouldn't you have to look at exactly what the plaintiffs are alleging at a factual level? What facts are they saying happened or didn't happen? And then the question would be, is that particular factual allegation, claim, assertion precluded by the state court's judgment?
I think both their individual facts, and if the court wanted to, it could look at the fact by fact in the 193-page state decision, and I think the court would see that all of the issues that the plaintiffs are trying to raise in the federal court were exhaustively litigated in the state court. But in addition, the overall legal standard here is the same. So I don't think the court even needs to get into the factual questions because as a legal question, the parents' disabilities were accommodated here. I think
I think as I read the plaintiffs' briefs, what they are suggesting is that the state's inquiry is whether, taken as a whole, the state made adequate efforts to reunify so that the DCF was not precluded from establishing inadequacy of the parents. While I think they're suggesting that if on one occasion a parent needed a sign language interpreter and wasn't given one, maybe in the global assessment, that wasn't enough to defeat the DCF's obligation to make adequate efforts to reunify. But that in and of itself is a violation of the ADA. I think that's the plaintiff's position. And so they should be able to claim whatever damages in here in being refused that particular accommodation on that particular day.
In the state court, Your Honor, the part of the state court's or the end of the state court's 193-page opinion conclusion was that everything possible was done in this case for these plaintiffs. So I would argue that to go back and say, well, could have an additional narcolepsy evaluation been done or something like that? Effectively, the state court has addressed that question and said, this is exhaustive. We've done everything. And it is impressive the number of PhD level evaluators and therapists that were put on this case and the years of efforts that were made to try to accommodate these plaintiffs.
If the parents are trying to get their kids back, why does Rooker-Feldman apply?
If they were trying to get their children back?
If they are not. Mr. Barrett conceded that is not the object of any of this litigation any longer. So if that's the case, and they're not litigating over the propriety of having lost parental rights, why does Rooker-Feldman apply?
Because there was a series of orders, Your Honor, throughout the course of the proceedings. It was not just one order at the end of the proceeding that terminating the parental rights, but because termination proceedings involve the constitutional right of the parents to a parent-child relationship, the state courts treat many of the stages in the course of the termination process that would otherwise be considered interlocutory to be in fact final judgments.
Rooker-Feldman only looks to judgments, state court judgments, isn't that right?
Yes, and what I was saying was each of these orders is considered a final judgment. So things such as visitation orders are treated as final judgments that are appealable in the state court. And the same with the specific steps. I submitted supplemental authority on that to the court, the In re Justin F case, in which the appellate court treated the challenge to the specific steps that were provided to the parents in DCF as an appealable final judgment. And the significance of that is that the specific steps lay out their court orders by the judge early on in the case at the order of temporary custody stage, in which the judge lays out specifically what DCF and the parents are expected to do in order to achieve reunification with the children. So to the extent the Rooker-Feldman would bar challenges to the specific steps, orders of particular evaluators, orders of particular visitation. Many of the issues that the plaintiffs have raised are in fact caused by specific orders within the specific steps or from the court itself. Now, I do concede Rooker-Feldman does not get rid of the whole case, but the collateral estoppel clearly does. Because the issues here were all adjudicated. But in addition, Rooker-Feldman applies to court orders along the process, such as visitations, specific steps.
So do you concede that these two plaintiffs have standing to seek injunctive relief for the kind of procedure that they were put through?
No. The district court correctly held that the plaintiffs have no standing here. They do not claim any present injury, but are claiming future injury if they should become engaged with DCF in the future. But that's purely,
or if they have more children.
As the court correctly concluded, it's far too speculative. Mrs. Houseman's in her 50s. She's no longer together with the father. It would require a whole series, an extenuated series of things that would have to happen in a chain of causation. So if the mother were able to adopt or to become pregnant in her 50s, and if she was with the same father and not somebody else, because the whole situation would be different perhaps there could be a different partner who might be very supportive. You'd have a different situation there. If they then acted inappropriately and their conduct came to the attention of DCF, and if DCF then conducted an investigation and decided to seek a court order to take custody, and if they decided to rely on predictive neglect at that point, and if the court granted the order, that the whole causal extenuated set of circumstances that would have to happen here before they would actually run in with DCF again.
Suppose the appellants here had filed a standalone ADA claim, say prior to to simplify this, prior to a final judgment in state court. What would be the state's position on these cases theoretically moving along parallel tracks? I mean, could that occur?
It could occur in the sense, in this particular case, in fact, what happened was the appellants, the plaintiffs went to our Connecticut Commission on Human Rights and Opportunities and filed a claim there in the course of the proceedings that were ongoing in the state court. And that commission looks at discrimination. Under state laws, it's discriminatory. State agencies such as DCF are prohibited from discriminating on the basis of disability, and they must take the ADA into account in providing services. That's all in state law, state statute. And so the plaintiffs went to the CHRO in 2008, right around the time of the first termination. They presented their claims. The CHRO rejected them, said they found no likelihood of discrimination here. And then they provided the plaintiffs with information on how to appeal that decision, which would have then gone to the state Superior Court as a parallel proceeding. The plaintiffs did not pursue that option, but that would have been open to them. They could have gone to federal court. I don't know what would have happened. There may have been some younger issues there, younger abstention problems. But there's nothing that I know of that would inherently preclude them.
You see how opposing counsel makes the argument of catch-22. They claim they didn't get a full and complete opportunity to litigate, that the kids were taken away from them because of their disabilities and no accommodation was made. And now they come to federal court and we tell them, sorry, you had your chance. So just deal with that allegation.
Yes, Your Honor, I totally disagree with the contention that it's a catch-22, because as I've explained, the issue here is whether the DCF services were accommodating their disabilities. And that was precisely the issue that was litigated in the state court. So there was nothing preventing them from fully litigating that. They did have issues with their counsel. They kept having turnover because they would fire their counsel. And then they tried several times they tried to present these ADA claims by themselves, just pro se. Tried to raise issues with saying they wanted a particular coordinator at trial. But I think the problem there was they were presenting their issues, trying to present them on their own without the help of counsel.
Well, excuse me, Ms. Rosemary, whether they were given a coordinator at trial, I take it, is not an issue anymore. Am I right about that? Because that would be a Rooker-Feldman kind of issue, I thought, or at least, I thought the argument was that the plaintiffs are not raising anything about what happened in court or any denial of any rights by the court. They're arguing denials of rights by DCF in the reunification phase of the case.
Correct. That's my understanding too. And because
is there any relevance? My understanding, and you can correct me if I'm wrong, is that the plaintiffs denied having disabilities during that process.
Yes, part of the problem when they tried to raise their requests for accommodations under the ADA in state court was that each time they did so, they emphatically denied that they had any disability, which then caused the court to say, well, what should I be doing here if you aren't claiming any disability or offering no proof of incompetency? So again, it was an issue with the way the plaintiffs were trying to present their arguments. It was certainly not.
Did this argument ever change? The I'm not disabled argument, was that a position they maintained throughout the litigation?
Yes, I believe they maintained it right from the very beginning. And then at the third and final termination trial, they were still maintaining that they had no disability, because they raised the issue at the beginning of that trial, and the Judge Keller questioned them and said, can you explain to me what the issue? At that point, they wanted someone in the trial to sit in the courtroom, and she questioned them and said, well, what is the disability? What do you need accommodated? And they said, we have no disabilities. So yes, Your Honor, throughout they took the same position that they were not disabled.
This is the point at which to conclude your argument, counsel. Mr. Barrett, you reserve 2 minutes for rebuttal. Thank you, counsel.
Thank you.
Thank you, Your Honor. What the court's questioning highlights is
the question is, explain to me what an ADA claim looks like on behalf of a plaintiff who denies being disabled.
Your Honor, the ADA protects not just people with disabilities, but people who are regarded as having disabilities.
Oh, sure, Mr. Barrett. That works if you are looking for a job and the employer says, I think you're retarded. I'm not going to hire you. That's a perceived disability, even if it isn't true, and the job was denied on the basis of perceived disabilities. How do you accommodate a disability that does not exist?
Your Honor, the question, I think that, well, you have to examine under the ADA, what you would do is say, first of all, do we have a person whose condition limits their daily life activities, right? This is what we see in every ADA case. That's absent from the Superior Court decision relied upon by the defendant. So I think a first step would be that even if the plaintiffs, for purposes of state court litigation, disclaimed a disability, because you must remember that the petition for predictive neglect that was lodged against them identified these deficiencies as the reason why they should not be parents.
Yes,
So
but
all these deficiencies were in their heads. It wasn't like, they had difficulty walking or difficulty
hidden disabilities,
manipulating a computer or something like that. These were different issues that were in their heads and were manifested by their behavior. And once their existence is denied, like your clients do, what's some judge supposed to do?
Well, Your Honor, the ADA protects mental illness and psychiatric conditions on the same basis.
I know that. Yes, of course it does. But sure, I don't recall, and I could be wrong, where ADA plaintiff recovered under the act where that person denied being disabled.
Well, Your Honor, perhaps that's the first element that the District of Connecticut should examine on remand. But as the questionings to opposing counsel, the questions raised is our fair shot at litigating the affirmative defense of issue preclusion.
But your client isn't disabled.
One isn't disabled.
Honor, they very well may be. In addition, Mr. Wiley.
They said they weren't. So what are we doing here?
Your Honor, in count 2 of the amended complaint, Mr. Wiley has pleaded a complaint completed a count of an ADA violation based on association with a disabled person.
There you go.
So there's an additional level as to beyond what accommodation was due to him, whether or not he was discriminated against, divorced from his status as having a disability.
Can I raise a question? We haven't reached the statute of limitations issue. Could you identify for me what DCF failed to do after 2010?
Yes, Your Honor. So it's the tailoring of the services. So when in June 2011, the 2009 termination decision was reversed. That restarted DCF's state law obligation to provide reunification rehabilitative services to my clients. That also restarted the coterminous,
and it was never given to them
to tailor any service to their disability.
So what happened,
including interaction with a designated responsible employee, 28 CFR 35.107.
Seemed to me to have taken place back in
no proof of compliancy, no proof of training, no proof of job descriptions.
That happened after June 2011. That even assuming a continuing obligation that would bring up all the old things, or just as a standalone violation after 2011, what happened then that was a failure?
Your Honor, it was a repeat of offering the same garden variety services that were not tailored in a manner to accommodate their disability.
Same service if Joe was disabled or non-disabled.
Try these things that we failed you out of.
Karen, she was just total wreck. She didn't know what to do right or wrong anymore.
What actually happened?
So they were beating on her disability.
Some program, and that in that program there was a failure to accommodate. You see what I'm saying?
That's it.
It's the same program, but your whole point is that program needs to be tailored.
It's a program supervised by the courts.
That happened after 2011 that is visible on the face of the complaint.
Well, Your Honor,
non-compliancy of administrative obligations.
The services that were offered and the methods of evaluation. And so you'll see in the Superior Court decision.
That seems awfully conclusory. I'm trying to get at what actually is it. But before you said, well,
the denial of modification of policies and procedures.
Was, narcoleptic, she fell asleep and they held against her
to avoid discrimination.
That's something that happened not in 2011, correct?
That's right, Your Honor.
At all costs.
What do you have that's comparable, in level of specificity after 2011?
Service referrals, Your Honor, to the same programs and providers that had already been attempted.
For now, same person, but now
And those are
described as
defective
having a
for
disability.
What particular reason that doesn't accommodate their disability?
Yes, Your Honor. So the state here, can win in state court by pointing to volume and duration. But of course, as Judge Parker's question.
Right, but you're the one who has to allege an ADA violation that takes place within the statute of limitations. So I'm trying to identify what exactly is it that is the accommodation that didn't happen, or the failure, or the exclusion of them from a service.
Administrative duties.
Right, Your Honor, it's the failure to provide a different range of services, these that were tailored
Modifications.
So I'm not sure how we were.
Not accommodations.
I'm just trying to understand what exactly it is that is the failure here.
Sure. So Your Honor, if you were to ask me what kinds of assistance might have been offered, for example, one-on-one coaching with someone who had dealt with the very disabilities that the state alleged my clients to have, for example.
Can't bounce a quarter on a bed because they can't make a bed right. Teach them how to do it.
Taking into account the disability. There are a range of accommodations.
Never been sober and clean around your kids?
They weren't even
opportunity to be sober and clean around your kids.
For purposes of the ADA, yes, Your Honor. They had, and you'll see. Oh, sorry, Your Honor. So for example, Ms. Hasman's narcolepsy. There is a point in which the Superior Court concludes, and it uses this language that it limited her daily life activities. And that's the first element of the ADA right there.
There you go. Perceived.
Well, this is a good time to conclude. Do you have a sentence in conclusion? I know we've used most of your time, counsel.
Thank you, Your Honor. Yes, for the reasons that our injuries are not caused by the state court judgment, and for the reason that we need a fair shot to rebut the affirmative defenses, we ask that the court reverse and remand to the District of Connecticut.
Thank you both for a very good argument.
That's it, ladies and gentlemen. What do you think? There's so much. I hope you guys heard me yelling some of the time. I'm not sure if it was kicking in, but this is where I continue to tell you, you need to affirm your rights. You need to ask, and you need to demand your policies and procedures, because without policies and procedures, we know the system cannot operate. Somebody cannot pull this shit out of the thin air. Again, the federal mandate to have the designated responsible employee to do all discrimination investigations, because if it's been identified, they need monetary control of the budget to be able to remedy the system, because it cannot happen again. That's the way law works. And again, when Congress made the finding in 1990, we will end discrimination by state actors and state players. It's real simple words, and it's whatever it takes. And again, there ain't so many new treatments and so many new diseases on the market every single day. We just don't even consider them. Like in my own child's case, they don't care about picture communication exchange systems. But yet, if there's another child, lap therapy dogs or whatever, the meaningless tools, where again, he's been trained for his effective communication to use the picture and communication system in a new environment, especially it's a training environment, would be that environment. And I believe what the Watley versus Keller case ended up coming out and saying, and you guys need to look up in Joseph W. In regards Joseph W. I think it was 2004, 2006, 2008, and then 2012. And then we finally got to the Second Court of Appeals in 2025 or 2020. I'm sorry. December 7th, 2020, that was just played out in New York, Second Court of Appeals. And if somebody needs that MP3, I have no problems in sending it to them. But please re-listen to it, guys, because you're going to start clicking on it now, what I'm talking about, on how they do not want the modifications. They didn't even mention the word modifications, where Title II uses the words explicitly, modifications to policies and procedures to avoid discrimination. So again, if you're dealing with incorrect people who already diagnosed you wrong, the courts found you to be diagnosed wrong, they're considering the father as being disabled and non-disabled. They did not separate the two. So in other words, the mother and the father were two separate beings. And then they were saying about the future probability of being in court. Well, if you're dealing with somebody that's a child who or another adult that might have a disability, and get them prolonged into more services like IEPs or 504s, or involved with the police department when the kids are older, truancy, whatever it might be, there's a great possibility you're going to have to run into another Title II system as a whole, not just as DCF, but as a whole, because you have the administrative duties, you have the department's administrative duties, you have the end users' administrative duties. They all got to answer to this chain of command on the same way they get their funding. And it should go all the way up to the legislative department. There should be in the judicial department, because, again, judicial oversees DCF. I mean, how many times have you seen court orders? Oh, DCF, we want you to do this. Or last month or a couple of shows ago, somebody was saying how they went in there and they gave them the opportunity another 30 days to come up with a game plan on how things were gone wrong. And it's like, if you don't know now, then how are you holding the child now? If you can't speak in that court now, then how are you holding that child now? It just doesn't make sense to me. Never mind the fact that is the designated responsible employee there by association rights, the parents' association rights, or seeing somebody on the streets would give you an association right to the disabled, as long as you were there in a meaningful way, like you came in a car together or something like that. Again, it would just be the fact of, without administrative duties being complied, without these ADA advisory committees, without policies and procedures, and without an auto correction system that when discrimination is identified, what stops it for the next person? Are they really going to come out and just don't tell nobody? That's where I'm kind of feeling it and seeing it is been going on for the last 35 years. And again, I feel they screwed up when they said the right to remedy. Yes, that would include not only a financial cost of what you guys did in the humiliation and the discrimination and tearing us down for being disabled people, but the fact of, yes, I do want the child back. And I objected to Joe on that ground. I says, Joe, screw it. If you got to sign contracts and say that you'll never let Karen, because that was some of the things that Joe did not recognize Karen's disabilities. Now, come on, as being a bad and harmful. How can it be? It just doesn't make sense to me. That's known discrimination. So if it's no different if somebody came up to me and say, Henry, we're not going to let you join this club unless you sign a piece of paper saying that you hate all minorities. It's stupid. It's the same application that was fought in the 60s is still being fought in 2020. And I'll say to 2025, going into 2026. 31 years after the ADA has been passed, almost. Well, we're 30 and a half years right now. And again, this is not lifetime funding, ladies and gentlemen. This was a funding that was supposed to start the system in auto-correcting itself. And again, it's as you got to look at it as a whole. You can't just say, well, I'm in this little hillbilly town and I don't have no accommodations here or modifications. I don't have the experts for my alleged disabilities or my physical disabilities. No, you can't have a modification without interaction. There has to be interaction. And yes, they can ask for what your disability is. They want a written note and how this would accommodate you. Most doctors are willing to go there. But once we start getting a little scarier into courts, most doctors want to run because they know it opens the door. Attorneys don't care. They love subpoenaing doctors because it ruins every relationship. Just like even school. When you go to an IEP in the school, and when I was doing it, because the state in 22 finally passed a thing about coercion, teachers cannot remain silent at an IEP on the child's needs. I would assume other states have got it, but you can always go to Rights Law and look that up. They are the number one source for educational needs, in my opinion. But yeah, so it'd be one of those things where now allegedly, on its face, because we got a state law, teachers are still being silent. And again, what do? They're just smarter at it. They just know that there's a law there, so they just have to be there a little bit more twisty or around their wording. Well, it could possibly benefit, or it will benefit. You see the difference in the two? That where the school system could say this, the team didn't recommend, and that's what it should be, is a team effect. There has to be a team effect when you're integrating systems with like DDS, Department of Developmental Services, DCF, or your local school board, because it's, again, services that are guaranteed underneath your rights underneath age 22 or 21, that you get these basic building blocks of skills in your life so you could be a productive little working ant. And that's what schools were about. Schools were not about football fields and proms and all this other marching bands and pep rallies. No, it was to give you your basic learning skills and your basic needs to manage your life. And again, we can all sit there and say that this could be applied to even, hands-on trades, which we're seeing out today is so bad in our country, but yet everybody is an IT person except for me. And I'll vouch to that one. But guys, I don't know. I'm going to say to you, if there's no questions on that one, but again, that's the overall lookout that we have to be looking out for, because this is an absolute slimy case. They came back as saying, well, I believe this is when they ended up saying termination of parental rights is not a program, service, or activity. And again, it's so crazy. It's not even funny where there's so many multiple factors where I believe on first engagement, they had to offer you a procedural safeguard. They had to offer you a list of disability modifications for your particular disability. And you have the right to review, and then you have the right to come back and say, well, I'd rather do this. That would be, more productive. And again, the undue burden part. Well, the only time they can give you an undue burden, for cost reasons, is after your ADA advisory committee reviews and looks the system over as a whole. If they have it in another area, like in education, well, then that specialty tool should carry over to the court systems or DCF or DDS, Department of Developmental Services. So again, guys, I don't know, but thank you, Classy. Yeah, so we got her coming on in 10 minutes, and whenever Darren wants to cue us out of here, we can go. Guys, you do the Oompa Loompa with me tonight, my little Polish
When
dance.
the courts aren't blue saying fair, you'll
get screwed everywhere.
The law isn't on your side. These corrupt judges take you for a ride. The courts don't want to even oppose. That's how we know it's corrupt. My disability has a name. We're all equal and the same. All alone in the courtroom floor, waiting for your hero to bust right through the door. It's hammering Hank every time. He's the one toeing the line. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't have. Hammering Hank, making sure you're not last. In the court they do have rules. They don't treat you like your jewels. You deserve all the commodities. Just because we have difference in our bodies. The law is made for us all. They don't protect us that have files on. He's the answer man you need to be calling. He puts it to an even field. Hammering Hank, he fights for the weak. Hammering Hank, there for you if you can't speak. Hammering Hank is the eyes you don't
sure you're not last. When you're a bit different, to phone you free. The playing field is equal, what do you bet? That judge has to toe that line. The idol makes sure every time. Hammerin' Hank, he fights for the weak. Hammerin' Hank, there for you if you can't speak. Hammerin' Hank is the eyes you don't have. Hammerin' Hank, making sure you're not last. Hammerin' Hank.